Good evening and welcome to Dad's Divorce. Tonight we're talking using questions that people submitted on Ask a Lawyer question on DadsDivorce.com. The first question comes from Mark in California. Can she restrain me from an affair? This question proposes whether or not this particular person's wife can restrain this gentleman from having an affair. In his question, he proposes an hypothetical that he has information that his wife may file a restraining order against him to prevent him from having an affair. The short answer to that is no. However, depending upon the jurisdiction, here in the state of Missouri, in order for someone to obtain a restraining order, that person's got to have imminent fear for their safety or their life. The fact that you may or may not go out and have an affair most likely will not be granted by the court for a restraining order. If anything, what a court may do is set it for a hearing, and in that case, your wife will not obtain an ex parte order for an order of protection against you or a restraining order, depending upon the jurisdiction that you're in. However, if a hearing is set, what will happen is within 2 weeks, a court will hear the petition that your wife filed, and in this case, it would be the petition to prevent you from having an affair. Depending upon the local rules and the statute, if that particular motion was filed here in the state of Missouri, a court probably would not grant even a hearing on it, would deny it. However, if the court would grant it, then like I said, you'd have a hearing set within 2 weeks, and then you'd have the opportunity to present evidence to refute the claim. If that motion was filed here in the state of Missouri, the way that you would defend that is pointing out to the court that there is no fear of safety or the fact that your wife is going to be in imminent danger, and the fact that you may or may not have an affair. So depending upon the jurisdiction, your wife may or may not have grounds to file an order of protection. However, taking that a step further, if your wife would file an order of protection because she does fear for her safety or that the fact that she may be in imminent danger, then the court may grant what's called an ex parte order of protection, meaning that on a temporary basis, the court granted the ex parte order and will still set it for hearing. Traditionally, it's set within 15 days. And during that time period, you will be served by the sheriff, and what the sheriff will do was serve you with a copy of the motion, ask you to leave your residence. Unfortunately, most times the sheriff will give you 10 to 15 minutes to grab up your personal belongings, leave the house, and either stay at a friend's or relatives, a hotel somewhere, but you cannot stay in the house or be on or near the premises until a hearing is set. At that time, the court will hear evidence based upon what has been put in the petition. The court can only hear the allegations that are set forth in the petition. If at the hearing your wife is bringing up new allegations, those will not be considered by the court. The court is only limited to what is put in the actual petition for order of protection. If a court denies the actual petition for order of protection, then you may move back into your house. A lot of times, this is the easiest way for wives to remove their husbands from the house. What they do is they go to the local courthouse, file a form order of protection, submit that to the court, and if they put in the magic words of I fear for my safety, I fear for danger, something along those lines, the court will either set it for hearing or grant an ex parte, and then for the next 2 weeks or so, you'll be removed from your house. A lot of times people ask, well, can I represent myself in this particular action? You can, but it'd be more beneficial for you to have a lawyer to represent you, because a lawyer will know the rules of evidence, the rules of procedure, and the way that these orders of protection are granted. An option would be, if you don't want to incur the cost of hiring an attorney to represent you or expend your personal time in defending it, you can enter into what's called a consent order of protection. On a consent order of protection, you're not consenting to the actual allegations that are in that particular petition for order of protection. You're just agreeing that you're going to stay away from your wife until the case is either decided, which would be your dissolution, which is your case in chief, or for a certain period of time. This way, if you enter into a consent order, you will not be penalized by the court and also will not be on your record. So if your employer were to do, or a potential employer were to do a history search on you, this will not show up on your record. Now, another avenue would be if your wife files for the order of protection, look for ways in which she is communicating to you. If she's communicating to you, then she's really violating her own order. I just had this client a couple weeks ago who was served with an order of protection. The wife stated that she felt for her safety and felt that she was in imminent danger whenever he was around. So she obtained the order of protection. It was granted on an ex parte basis, so the sheriff came to the residence, served my client. He had 15 minutes to grab his belongings, and then was asked to leave the premises and not return until final order of the court. 2 weeks later, the hearing was set, and we were presenting the evidence to the court, and what we had were email communications from wife to my client, which were invites for him to come over and see the children. And in the actual petition for order of protection, she stated that he was a danger to the kids and a danger to herself. Well, in that particular case, the judge denied the motion, and then my client was allowed back into the house. So sometimes when you're served with an order of protection, it's the easiest way for the wife to remove the husband from the premises without having to set up a formal hearing with the court, incur attorney's fees, and go through the formal process. Our next question comes from a gentleman in Colorado, and in this particular question, the husband allowed his wife 2 weeks to go to Colorado to baptize their son. She went down there. They baptized in her hometown of Texas, and now she's refusing to come back. Under this particular situation, it appears as if he gave express permission for 2 weeks and 2 weeks only. My first question to that would be, do you have some type of written correspondence, whether it be an email, a text message, a letter, something indicating that you agreed to only 2 weeks and 2 weeks only, and once the 2 weeks have expired, then she needs to come back to the state of Colorado from Texas with your child. She can stay down in the state of Texas, but your child must be brought back to Colorado. It doesn't appear as if there is a dissolution that is currently pending here. So what I would do is get a dissolution on file, because under the Uniform Child Jurisdiction Act, you're looking at a 6-month residency requirement. And in this particular question, the gentleman states that the child has been born and raised in the state of Colorado, and it appears, at least from my understanding of the question, that I believe you've fulfilled the 6-month requirement. If not, you're going to need to wait at least 6 months before you can file within the state of Colorado. And that way you can prevent mom from filing in Texas and having Texas take jurisdiction if she's going to stay down there for an extended period of time. But if you have this written agreement between the two of you, then she must bring back the child within 2 weeks. If 2 weeks have expired and she has not brought back the child, then your remedy would go, I would advise you to talk to a local law enforcement agency, show them the written agreement between the two of you, and then they can take measures to bring mom back. If not, you may have to file what's called a motion for habeas corpus or a writ of habeas corpus, because she unlawfully is withholding your son out of the state of Colorado and in the state of Texas. And then the state of Colorado will basically order the state of Texas to have mom bring back your child to the state of Colorado, and then you can deal with the dissolution in the state of Colorado or any other remedies that you are seeking within your motion or writ for habeas corpus. We have another question from a gentleman in the state of Oregon, which states that he met with his wife and his wife's attorney at his wife's attorney's office. He decided to settle their case, and now is having what is called buyer's remorse. It doesn't matter whether or not anything was signed. It matters what has been filed with the court and if the judge has signed off on it. If the judge signed off on it, then depending upon your particular jurisdiction, you may have 30 days and file what's called a motion to set aside the settlement. If you're within the 30 days, you file the motion to set aside the settlement. Then you ask the court to reopen the case and the evidence, and you proceed with the actual dissolution itself. However, if you have not signed anything and nothing has been filed with the court,